In this presentation on the dangers of no contest clauses, I explain that no contest clauses are often used to protect lazy and dishonest attorneys. After preparing a few estate plans, an honest and conscientious attorney soon realizes that estate planning, even in simple situations, is not easy. It takes work. With this realization, the new attorney faces a choice: work hard to prepare customized documents for each client, or pawn off cheap boilerplate documents on every client. Unfortunately, many attorneys choose the easier route. For these lazy attorneys, no contest clauses are a dream come true. The blunt reality is that no contest clauses allow attorneys to produce cheap, shoddy documents without any fear they will ever be held accountable. These cheap documents, no better than a cheap online $129 will, open the doors wide to mistakes, mismanagement, and manipulation, especially to dictator fiduciaries. If the honest beneficiary who is being cheated or manipulated attempts to sue the fiduciary and also attempts to blame the attorney can easily hide behind the fiduciary, who then hides behind the no contest clause. The no contest clause directly benefits the lazy attorney and protects the lazy attorney from any responsibility for his laziness or incompetence. Consider the following cases and examples. First, dishonest attorneys may insert no contest clauses into documents to advance their own personal agendas. In the Georgia case of Callaway versus Willard, Attorney Callaway drafted the client's trust with the provision that trustees were to receive a minimum $35,000 annual fee. Attorney Callaway then persuaded his client to name him, Attorney Callaway, as the first trustee. Finally, Attorney Callaway was careful to insert a no contest clause in the trust. The client died, and Mr. Callaway promptly failed to perform his trustee duties, but he took the $35,000 annual fee anyway. When the honest beneficiaries confronted him, Mr. Callaway's law firm quickly pulled out the no contest clause against the beneficiaries. Fortunately, the court removed Callaway and refused to disinherit the three beneficiaries for bringing their honest contest. Second, lazy and dishonest attorneys may insert no contest clauses into documents to divert attention away from their incompetence and malpractice. In the New York case, In re Estate of Strawlham, the attorney pawned off a cheap will on his client that gave the executor broad, dangerous powers. And of course, there was a no contest clause. After the client died, beneficiaries sued the executor for breach of conduct. The executor promptly hid behind the no contest clause. Fortunately, the court rejected the no contest clause. The court then stated that, quote, the increasing practice of attorneys in giving fiduciaries almost unlimited powers with a minimum of obligations is a serious potential menace to all persons interested in estates. The court then stated further, any impairment of a fiduciary's obligations through a no contest clause is contrary to public policy. Allow me to repeat what was happening in the Strawlham case. An attorney drafted a typical cheap will that gave the executor typical unlimited powers and very few obligations. And then the attorney protected the executor from fulfilling any obligations by including in the will a no contest clause. If that does not outrage you, then you have never experienced the injustices that occur again and again in estate planning conflicts. Consider this example. Suppose an attorney prepares a cheap will with a no contest clause and then witnesses the client sign the will. After the client dies, the honest beneficiaries have proof that the client, their benefactor, their father, for instance, was on heavy-duty painkillers at the time he signed the will. They contest the validity of the will, but they are threatened with disinheritance. Of course, the lazy attorney who witnessed the signing is more than happy to hide behind the no contest clause. Lazy and dishonest attorneys are enamored by no contest clauses for the following simple reasons. 1. The clause validates the attorney's brilliance with his client. Mr. Smith, we include in your will a provision that prevents beneficiaries from creating any problems. We call it a drop-dead clause. No one will dare contest your document for fear they will be left out. Dropped dead. Laughs all around. Until the client dies. Conflicts arise, and the courts are not telling honest litigants to drop dead. But the clause still shields the dishonest attorney. 2. The clause shields attorneys from malpractice claims. If an honest beneficiary ever thinks about suing an attorney for producing a cheap boilerplate document, the attorney joins forces with dishonest fiduciaries or beneficiaries and simply accuses the contesting beneficiary of violating the no contest clause. 3. The clause is so easy for dishonest document mill attorneys to include in their cheap documents. The attorney is not forced to do any work in effectively containing conflicts. Instead, the attorney just inserts the cheap no contest clause in the will or trust and asks the client for the check. As a probate litigator, when I see most no contest clauses in a trust or will, I immediately know the estate planning attorney who drafted the will or trust was, to be generous, thoroughly ignorant of the laws regarding no contest clauses, and in some cases intentionally used no contest clauses to protect themselves from malpractice claims. Attorneys who use typical no contest clauses are committing malpractice. They are committing malpractice. An attorney using these typical boilerplate no contest clauses is like a surgeon performing brain surgery, wearing boxing gloves and holding a hacksaw. My name is Craig Hughes. I am a probate litigator. That means I represent in court people who fight inheritance manipulators. I represent people who fight inheritance abuse and fraud. I am also an estate planning attorney. I assure you that attorneys often use no contest clauses to shield themselves from their own incompetence, laziness, malpractice, and dishonesty. More information about this brutal fact, including legal citations, is found on our website, estatesurpriseplanning.com.